Few sounds bring more joy than the faint first cry of a newborn. It is the sound of 9 months of hopes and prayers being answered. For the Motswane family, it was the sound of their dreams coming to fruition.
My labor started in 2000, on the 6th, 2000 in December. You know, I did my house chores as normal. 2007, sorry. 2007, I did my house chores as normal, you know, because, you know, when you go to ANC, they tell you that you don't have to rush to the hospital, you know, because the process of giving birth, it takes longer, you know. So my husband fetched me. I went to Lilenguni. Then was, I think it was.
But when you got to the hospital, the child had been put in an incubator. And we didn't know why. And then that's when Gloria explained to me that, no, the birth was prolonged. And Gia had seizures immediately after being born. And they just showed the child to Gloria and quickly took the child to ICU ward.
The joy was unfortunately short-lived, soon to be replaced by anxiety and confusion.
I mean, it's you know, our baby boy just arrived, Morfatsing, and we were very excited, but also confused about now what has happened, you know. Then we discovered that he has a condition called cerebral palsy, which we didn't know what it was. And we started doing background check and information on that.
What the Motswanes also did not know then was that their nightmare was a fallout of callousness on the part of hospital staff. It was only years later, while discussing their son's medical condition with a family friend who happened to be a doctor, that it dawned on Gyamogetswe's parents that they were victims of medical negligence.
I was running a business which was not doing too well, so going body legal and suing people didn't seem like an option for us. Then we got a referral by somebody who said that they know lawyers that can help us, who work on a system where they will take the case to court. Should it be successful, then there's an amount of money they take from this payout. Should it not be successful, we don't pay anything.
The grain of attorneys offered to take up the cudgels on behalf of the Motswanes without charging a single penny up front. For the family struggling to keep up with expenses involved in taking care of a child with special needs, the offer was a godsend. Wim Cranov attorneys secured their first victory on October 25, 2015, when the Gauteng High Court ordered an interim payment of 5 million rands. It also marked the beginning of souring of the relationship between the lawyers and the Motswanes.
And for me, it didn't make sense, you know, to say, the state has paid him 1 million, why does he only have 200,000? And that's when problems really started. I sent a few emails asking questions of that nature to the law firm, sent the same type of inquiries to the trust firm that has been tasked with looking after the trust fund that has been created for GIA.
The trust at the center of this bitter battle is named after Gyamogetswe, a heartwarming word that means I am welcome. For the 10-year-old, Chris Hani Hospital staff's negligence has meant that his journey has been most unpleasant. As other children around him go prancing, Gia struggles even to sit up straight. Simple things like swallowing are an exercise. As the boy battles towards normalcy, his parents and designated caretakers are busy waging wars of a different kind. The courtroom battle with the hospital ended in 2016 with another 26.6 million rands being deposited with the trust. But the fight continues.
That was an interim award that was made by the court in view of the fact that the defendant had at that stage sought a postponement of the quantum trial. It was agreed that an interim award of 5 million rand would be paid. We have sat down with the parents and we have explained to them in the circumstances whether we can deduct the expenses and a fee component from the interim award, bearing in mind that we've been dealing with this case since March 2012. A period of 3 years and 8 months have lapsed without the attorneys debiting a single fee or rendering an account for experts to be paid. I did not appoint this trust. I made a recommendation to the court and the court had to approve that recommendation. And once the court is satisfied that this trust meets all the requirements, the court appoints the trustee.
The ongoing tussle over who gets to control the funds in Gia's name seems to have taken the focus away from what matters, the child's needs and welfare. After the court judgment, it is the responsibility of a case manager to look after the child. In Gia's case, it was the job of Ophilayo Case Management. But with 15 negligence cases under management, one can only guess the amount of personal attention they would be able to pay.
It's very advisable to have case management, mainly because in instances like this with medical negligence, it's not on a regular basis that you see that the beneficiary is in contact with the trustees, especially where the trustee is not a family member. So the case management will assist or will act as a median for communication between the beneficiary and the trustees in the event that none of the trustee is a family member.
For this, we didn't know this case management company until the lawyers introduced them to us. We didn't know this trust management company until the lawyers introduced them to us.
We've debated that at length, and we felt at the time, because of the occupational therapist's involvement in assessing Kia and any other cerebral palsy child, is that they are acutely aware of the child's condition and how they can improve that child's condition. Yes, you can get another case manager, but what better case manager to get than your occupational therapist that knows the child, that has assessed the child, that is aware of the child's shortcomings, his medical interventions, his treatments, and all of that.
The family is unhappy. The lawyers are bitter. The State Health Department is poorer by 30 million rands, all in the name of a child who continues to suffer for no fault of his and is actually disadvantaged by the ongoing tug of war.
As soon as we got to the law firm, they said, sorry, our mandate with Kia as our client and Laura as the plaintiff is terminated. We've paid you all the money that we're supposed to pay, and we can't help you. And we thought, okay, but we ended up there because of you guys.
If I can read to you the email that I received from the father, which says, "Wow, exclamation mark, this is amazing. You have really outdone yourselves. I'm at a loss for words, but I guess another thank you won't hurt anyone. Kia is fantastic. He did his Botox procedure in April, and that has helped him immensely with his left hand in particular, because he's now able to use it to grab objects. Gloria's the happiest, enjoying being a great mom, fixing Kia great healthy meals from a beautiful kitchen in her new house. This would not have happened without your outstanding efforts. Thank you once again. Wishing you all the best with your other cases. Pass our regards to the rest of the team."
At the center of this litany of broken promises and manipulation of legal system is a child's future in jeopardy.
Kia Mogetsu's ordeal highlights the gaping holes within the system. With 31 million rand from state coffers in his name, Kia still cannot get all the facilities he needs and can afford. His ordeal cries out for the strengthening of follow-up processes and stringent supervision to ensure that beneficiaries does actually benefit. For ANN7, Regina Jafta, Johannesburg.